Good morning to all. Registrar, please call the matter.
Thank you, Madam President. Hearing of the 15th Annual Caribbean Court of Justice International Law Moot. In the matter of Moot 001 of 2025 between the State of Antigua and Barbuda and the Republic of Guytrin. The members of this morning's panel are Madam Justice Rajnath Lee, President and Presiding Judge, Mr. Justice Jamadar, and Madam Justice Ononiwu. May we have the appearances, please?
May it please this honorable court. I am Kadeen Brown, and I appear on behalf of the claimant states Antigua and Barbuda. Appearing alongside me are counsel Mr. Ravi Davis, and we are instructed by counsel Mr. Moya Lin.
Thank you.
May it please the court, I am Antonisha Henry, appearing as senior counsel on behalf of the Republic of Guytrin, along with junior counsel Simon Lamb, and we are instructed by Teroni Hunt.
Thank you very much. And a good morning to all. Allow me to just take a couple minutes to make a point as we begin this morning. We wish to remind you that on the brief that you would have received, you would have seen the blurb on court etiquette. It contains some important guidelines. We wish to remind everyone in the court, and especially those taking part in our 15th CCJ International Law Moot, that the core values of respect and courtesy must be extended not only to the court, but to your colleagues, the CCJ staff, and all those with whom you interact over these 2 days. So with that said, let's begin. Ms. Brown, are you ready? Yes, you may start.
Our submissions before the court today concern the actions of the Republic State of Guytrin, who have implemented local content measures that are in breach of the revised Treaty of Chaguaramas, RTC. These provisions are the local content policy, the production sharing agreement between the government as well as the Hex Mobile, as well as a community agreement between the indigenous peoples of Guytrin, the Kalino and Locano peoples, which we will dub the IPA. We believe that these measures are in breach of the revised Treaty of Chaguaramas because they give preferential treatment to Guytrinian nationals. And this discriminates against our rights as Antiguans to establish businesses, to provide services, as well as to seek employment within Guytrin's petroleum sector. Permit me, Your Honors, to give some brief facts of this matter.
Yes, certainly.
Your Honors.
But tell us how these facts relate to your contentions, yes?
Yes, Your Honor. Your Honors, the case at bar calls for a balance to be struck between rights and responsibilities. We say this because the aims of the RTC, embodied within the preamble of this document, is the access by nationals to the collective resources of the region. This includes the rights of member states, such as our nationals of Antigua and Barbuda, and our citizens to be able to work within this sector, to be able to establish businesses, and to be able to provide services without discrimination on the basis of nationality. And this, we contend, are rights which are enshrined in the RTC at Articles 7, 32, 36, and 46. We submit that the Republic of Gaitrin has violated these articles, and therefore they infringe on the rights of our nationals, and by extension, the nationals of other member states, when it's implemented a local content policy in the year 2020, by its subsequent contractual agreement with American multinational ExxonMobil, and through its government-backed community agreement between the Kalino and Locano indigenous groups of Gaitrin. I will be dealing with these arguments as relates to the breach of Articles 7, 32, 36, and 46. Thereafter, co-counsel Mr. Davis will submit that there is no justification for Gaitrin to implement these measures which restrict our rights under Articles 32, 36, and 46 in a responsible way that conforms with the Articles of 43 and 47 of the revised treaty. Your Honors, there are two primary submissions that I wish to make before the court today. The first is that the local content initiatives or measures of Gaitrin constitute new restrictions and are therefore a breach of Articles 32 and 36 of the RTC. The second submission is that the initiatives result in a breach of the rights of Antiguan skilled nationals who wish to seek employment within Gaitrin's petroleum sector under Article 46. We further submit that the exercise of these rights by our nationals has been discriminated against on the basis of nationality only, and that is a breach of Article 7 of the RTC. I'll now begin my submissions with the Article 32 breaches.
Ms. Brown, before you get to whether breaches have been committed, I wanted to first have you establish whether there are acts of the state in this particular instance which may be challenged. And I'm particularly interested in the submissions which Antigua and Barbuda have made in its written submissions with respect to the community agreement. So I'm drawing you to paragraph 4 of the written submissions of Antigua and Barbuda. And I would ask if you could, before getting into whether particular breaches have been committed, elaborate a bit on the argument that has been made that by virtue of the government granting permission to ExxonMobil to exploit the resources, or by virtue of the government protecting the land rights of indigenous peoples, the actions of ExxonMobil should be attributed to the state. Could you elaborate on that argument, please?
Yes, Your Honor. So we are submitting that these initiatives or these measures of Gaitrin that you have just alluded to, they are all provisions that are actions of the state because they are giving clear and specific instructions to the operator and contractor, in this case, ExxonMobil, for them to carry out their operations within the petroleum sector. So for instance, the local content policy utilizes terms such as shall give and shall undertake. And the PSA, the production sharing agreement as well, mentions similar language. And then the community agreement also embodies language of those two agreements. Now, in the case of Maurice Tomlinson and the state of Dominica, which was adjudicated by this court, breaches of international obligations, which are based on the actions of all three arms of government, do constitute something that is justiciable in the court. And so the actions of the government of Gaitrin in implementing these policies can constitute or do constitute actions of the state, because the local content policy, which began all of the rest of the agreements, this policy is an action of the executive, which is an arm of the government.
But specifically the community agreement, because my question is targeted at the community agreement. The submission of Antigua and Barbuda is that by virtue of the government presumably having granted permission to the corporation to exploit the resources in the area, and by virtue of the land rights of the indigenous peoples being protected, I understand your submission to be that by virtue of those two considerations, the actions of the corporation can be attributed to the state. I'm specifically asking you to zone in on that particular submission and to elaborate on it. In other words, how do those two considerations necessarily lead to attribution of the actions of the private corporation to the state of Gaitrin?
Yes, Your Honor. So we submit that the actions in this agreement, the Indigenous Peoples Agreement, can be attributed to the state for the very reason that the operations, the offshore operations, as the facts tell us, are located on lands that are owned by these indigenous groups. And so in order for the Kalino and the Locano people, these are their lands. And so for the PSA to continue, then it is necessary for them to engage in this contractual agreement with the indigenous peoples. And if it is that we can juxtapose.
Ms. Brown, before you go, keep going. There are three things that we are talking about here, right? We're talking about the local content policy, which clearly is a policy created by the state, by the executive, yes?
Yes, Your Honor.
Then we have a document, which is an agreement between the state and a corporation. That is the production stating agreement.
Yes, Your Honor.
And then you have a third document, which is between the corporation, ExMobil, and the community agreement with the indigenous groups. Yes?
Yes, Your Honor.
If it is in the community agreement, let's call it that, yes? If in the community agreement, the corporation overcommits or over extends restrictions, yes? Is that attributable to the state? Do you understand what I'm asking you? So that you have first an executive document, which is the policy document. Then you have an agreement between the state and the corporation. State is involved in that, that's an agreement. But then you have it in the corporation and groups. Yes. If in the third document, the corporation goes and commits in ways that, let us assume for the moment, they are exclusive, yes? Does that necessarily mean that they are attributable to the state?
We submit, Your Honor, that it can be attributable to the state for the very reason that if it is that we can, well, first of all, because the government, by virtue of the PSA, would have given ExMobil the permission to undertake this agreement. And if it is that they're to do their coastal operations, it is on the lands of these very people. And so these people are indigenous people, and so their land rights must be protected. And so the government would have indicated in their production sharing agreement the necessity of having this agreement with the indigenous groups. And then if it is that we can juxtapose what happens in the
PSA doesn't say that. On the fact matrix that you have, PSA doesn't say that. PSA simply says that it is required to give preference to guide Trinidadian suppliers. And it's conditional. Where their bids are competitive, so that where you have bids that are competitive, equal, give preference to. On the fact matrix, is there anything in the PSA that suggests that what was done in the community agreement had to have been done?
Yes, Your Honor.
Where is that?
So by virtue of the very language that the PSA uses, the mandatory language, where it's saying that they are required, the operators and contractors are required to do a particular thing, which is to give this, to give the bidders the preference, and then that extends over into the IPA, because this community agreement, the tenderers have, or the HexMobile, my apologies, HexMobile has then committed to giving tenderers, who are tenderers that will be drawn from this pool of persons that HexMobile ought to contemplate, then it is that we are extending that this PSA further extends into the IPA.
Yeah, okay.
Yes, I think we catch what you say. And I believe you say, look, when you look at the PSA, out of that comes the obligation of HexMobile to enter into these agreements with the indigenous people. Is that your point?
Yes, Your
Yeah,
Honor.
I think follow you. So I think because we're running out of time, we need to let you move on. I'm not sure how much time she has, but yes. If you could, yes, you were going to 32 and 36.
Yes, Your
And
Honor.
you were going to show us how the facts assist your case, support your case. Go ahead, please.
Yes, Your Honor. Now, as it relates to Article 32, it is our submission that these agreements breach and the policy breaches Article 32. Article 32 prohibits explicitly the introduction of new restrictions on the right of establishment of nationals of other member states. In defining this right, Article 32, paragraph 3, then goes on to indicate that the right of establishment includes the right to engage in non-wage earning activities, as well as the right to create and to manage economic enterprises. The jurisprudence of this court in the matter of, or the case of Cabral Douglas and the state of Dominica in 2017, as well as a decision that we wish to rely on from an international court, the European Court of Justice, that matter being the Commission of European Communities and the Kingdom of Netherlands, both give crucial guidance as to what the term new restriction means. A new restriction in Cabral was indicated to be the introduction of a new or additional requirement. And as it relates to the case of the Commission in Netherlands, that case specifically stated that a new restriction is any national measure that has the effect of hindering or making less attractive the exercise of the rights. And the restriction will then be considered to be new once it is that it is enforced or it came into effect after the entry into force of the revised Treaty of Chaguaramas. And for that, we turn to Dr. Berry, as well as Article 234 of the RTC, which indicates that this was on January 1st, 2006. And so the LCP, the Local Content Policy, Production Sharing Agreement, and the Community Agreement would all constitute new restrictions in that light.
Could you then just very briefly let us know how is the right of establishment restricted by the facts that you saw here?
Yes, Your Honor. So as it relates to the local content policy, operators and contractors are to give first consideration as well as adequate opportunity to the Guytrinian suppliers. And as it relates to the production sharing agreement, which is the extension from the local content policy, the HexMobile is mandated to then give preference, my apologies, to Guytrinian suppliers during the bidding processes. In the community agreement, which stems from the production sharing agreement that HexMobile has with the government, they are committing to the indigenous peoples that they are going to give preference to any tenderer who gives the greatest opportunity to the indigenous groups. And as was mentioned earlier, these indigenous groups, or these suppliers, that would be given preference are those from the general pool of tenderers that HexMobile is required to contemplate. Now, the defense will argue that the provisions do not shut out the participation of community members in totality. But based on the groundwork that we just laid in relation to new restrictions, we are submitting that the national measures do not necessarily have to have this effect, a total shutting out, in order to constitute a new restriction. All that is required is for this measure to hinder or to make less attractive the rights.
Ms. Brown, I wanted, because I didn't hear you speak to it, do you consider or does the state of Antigua and Barbuda consider the training or capacity development provisions in these three instruments, the local content policy, the production sharing agreement, and the community agreement, to impair, that's the standard you're arguing, impair or hinder the exercise by community nationals of the right of establishment or the right to provide services? So you spoke about other elements. I want you to zone in on the training or capacity development elements, and I'd like to hear whether you consider those to impair the exercise of the right of establishment or the right to provide services.
Yes, Your Honor. So in the training that HexMobile must undertake, which is the provision that is given there in their contract, there it is that another preferential element is added, because the preference is to give the training, or the training is to be accorded to the Guytrinians. And so therefore, other member states, nationals of other member states, will be left behind where that is concerned. As well as we can contemplate the fact that as a region, we from different regions, we live and work in other regions. And so if it is that as an Antiguan, already living or working or having my business in the member state of Guytrin, then whatever opportunities that the government has now enforced that HexMobile is to undertake, then I will not be a party to that, or I'll be lower down on the totem pole where that's concerned.
Then that they should do training throughout the region for everybody to make it equal.
Can you just repeat the question, please?
Saying that therefore they should do training throughout the region for everybody to make it equal, non-discriminatory.
Not discriminatory.
That is what would be reasonable.
That would be reasonable. If it is that the training is accorded to every single member, then it would not be discriminatory, because all of us then will be considered on the equal footing that the RTC contemplates for us to be considered under.
Before you go on, and going back to Article 32, the state of Guytrin has made an interesting submission at their paragraph 4. They say that under Article 32, CARICOM nationals, I get the impression they're saying, can establish a business in Guytrin and therefore will benefit from the priorities accorded to Guytrinian suppliers, as they too will have Guytrinian businesses. What do you say of that?
Well, to that, Your Honor, as it relates to someone who wishes from Antigua, who wishes now to establish a business or already has a business that the petroleum sector will benefit from.
Has a business where? In Guytrin?
In Guytrin, yes, in Guytrin. They would still be accorded preferential treatment to the Guytrinians by virtue of the fact that the language that it is using says explicitly that preferential treatment ought to be gathered or to be guaranteed to these individuals. And so if it is that our nationals who either have their business already there in Guytrin or wish to establish their businesses, they will not be given this preferential treatment, or they won't be, not in terms of giving preferential treatment, my apologies, but they will not be given equal consideration on the merits of their qualifications, for instance. And so...
But pause. But is there anything, that's on whether they get a contract, but is there anything in the LCP preventing them or hindering them or impairing them from establishing a business?
Generally speaking, no.
So they can do all of that. Your point is that if they do all of that, their chances of getting that's what's hindered or impaired.
Yes, and as
No hindrance to establishing per se.
not in a general sense, Your Honor. But the establishment, because we do recognize that the local content policy is specific to the petroleum sector.
No. I'm talking about establishing a business, a petroleum business-based enterprise. There's nothing stopping them from establishing a business
No, but
or from moving capital into the country.
no, there would nothing be stopping them, but they will be reluctant to do so.
Right.
And therefore, they will be hindered. Their right to do so would then be hindered or made less attractive. If you know that, you will not be given the consideration or a proper consideration on the merits of the matter.
Ms. Brown, we follow you on that completely. We are told that your time has run out, but we know we have engaged you for a very long time. So we want to give you a couple minutes to quickly wrap up, but more so to pay attention to your Article 7 point. Please take it from the Article 7 and then you can wrap up nicely for us.
Yes, Your Honor. So as it relates to Article 7, our primary submission there is that it's discriminatory on the basis of nationality only. And for this, we use the test in Shanique Myrie, which was decided in this court. And that is a three-pronged test. The first is that the treatment is supposed to be worse or less favorable. The second is that it is to be accorded to someone that has similar circumstances to the complainant, with the only difference being their nationality.
Ms.
And then
Brown, I know you have a limited time, and I'm really curious for you to address two questions really quickly. One, is Article 7 a standalone provision?
no, it is not a standalone provision.
Okay. And secondly, I would like you to please clarify, there's a submission in paragraph 8 of your submission that refers to the status of the parties as disadvantaged countries. Assuming one or more of them is a disadvantaged country, what's the relevance of that to a determination of whether Article 7 has been breached?
Could you please just repeat that last question?
There is a mention in your submission on Article 7 that both countries would be classified as disadvantaged countries. I would like to know what is the significance of that being mentioned in the context of whether Article 7 has been breached. What's the relevance of either of them being a disadvantaged country to a determination of whether Article 7 has been breached?
So as it relates to being disadvantaged, they're in similar positions in terms of the things that are happening with them, or the things that they are facing. And so if it is that based on these initiatives or these measures, national measures that have been implemented, they will not be given an equal opportunity in this regard. And so the treatment is going to be different. And based on the test that is laid out in Shanique Myrie, then there it is that they will not be given this adequate opportunity, and on the basis too of the fact that they have similar qualifications or similar, they've met the requirements really, but they are unable now to be accorded on the merits of their matter because of the fact that they are being discriminated against.
I think we follow your answer, Ms. Brown, and you have 30 seconds to wrap up.
Your Honor, if I could just briefly mention the 46 points, or is it that you
Well,
would
if you
rather?
want to take your 30 seconds and mention it, go ahead.
Okay, I'm guided. Now, generally speaking, we are contending that the restrictions are new. They all hinder, they make the rights less attractive, and it is in contravention to the revised Treaty of Chaguaramas, Articles 32, 36, and 46, including the right to seek employment within the member states. And if it is that these rights are hindered, then of course it is discriminatory on the basis of nationality only. And so we submit that these are breaches committed by Gaitrine and they need to be addressed.
Thank you very much.
These are the extent of my submissions.
Thank you very much, Ms. Brown. We appreciate your time. And is it Mr. Davis? Yes.
May it please the court. Your honors, the case of rights and responsibilities continues. We submit that the state of Gaitrin had certain responsibilities that it had to follow through with if it was to properly implement restrictions to the exercise of rights. And we submit largely that these responsibilities have not been met. And these responsibilities come by virtue or by way of Articles 43 and 47 of the revised treaty. And these can be largely categorized as some procedural and some substantive. I think, Your Honors, that I wish to deal with the, well, not I think, I do wish to deal with the procedural arguments first. And then if I am, and then of course, if time permits, I wish Your Honor just to deal briefly with why we say the state of Gaitrin has no protection. If I can then turn to the procedural arguments relating to Articles 43 and 47, and the first, Your Honor, is simply the issue of notice. And you will see from the plain language of Articles, well, both Articles 43 and 47, that the government of Gaitrin was required I think we're trying to pull it up, Your Honors. But on the Article 4.
Okay, we each
Okay.
have, so
We
don't,
have.
Very well.
don't
Very
let
well, Your
time be
Honors.
consumed in that.
So Article 43 requires that upon the implementation of restrictions, the state of Gaitrin was to notify the competent organ, which in this case, or competent organs, in this case, COFAP, the Council for Finance and Planning, and COTED, the Council for Trade and Economic Development. And it specifies, Your Honors, in 43 that that notice must be given within 3 working days. 47 also has a notice requirement, but that requirement isn't as specific as it relates to the 3 working days, but it does say on a 2-pronged test that if the state intends to implement restrictions, it should notify of the intention, and if it has, then it should immediately notify that it has implemented restrictions. Our argument on that point simply is that Gaitrin has not notified the competent authorities, period. In fact, there is evidence that it was nationals of other member states and other member states who actually moved the Caribbean community and quoted to inform them of the implementation of these restrictions. And so we argue, we submit that the state of Gaitrin has not met the notice requirement.
Mr. Davis,
that is-
just
Yes, Your Honor.
to interrupt you a little bit. So are you saying that these are absolute requirements?
Yes, Your Honor, we are in fact saying that they're absolute. They've given the language, the explicit language of both sections, that the requirement to notify is absolute.
And so that in your submission,
On that basis alone, Your Honor,
Yeah.
they at
Agreed.
least have breached that notice requirement. Yes,
they cannot enjoy the benefit of restrictions.
and in fact, Your Honor, if I can continue, the restriction, the leverage that the RTC provides to implement restrictions on the 43 is subject to 43.5. And if I can take the court then to 43.5, which then speaks to the issue of COFAP establishing procedures for periodic consultations, and then 6, that goes on to talk about what those consultations should look like. We say that the implementation being subject to 43.5, the only way that the competent organ could have been aware of the restrictions to trigger this process would be if they were notified.
For this action in 2024, correct?
Yes, Your Honors. Well, yes.
In July of 2024.
Yes, Your Honor.
But in 2022,
Yes,
this
Your Honor.
came before the heads of government,
Yes, Your Honor.
and they established a working group on local content to
Yes,
make
Your Honor.
recommendations and develop a policy and plans and so.
Yes, Your Honor.
Does that in any way, the fact that the heads of government acted in a formal way and created a committee to address this issue, does that in any way mitigate in the interim the what you say are the absolute requirements?
Honor, Your Honor, our submission would be that what that does is perhaps assist the state of Gaitrine in now dealing with the conundrum that it has found itself in. The issue of mitigation, Your Honor, we submit that that subsequent act by the conference unquoted does not mitigate, because Guyana had a duty, Gaitrine had a duty to notify the competent organs, and the evidence shows that they have not, and that
You mean they
CARICOM
gave no formal notification, but clearly in 2022,
yes.
they all had notice because they acted.
Yes, and so
In other words, you are relying on a very formal formality that Gaitrine did not itself notify, even though, in fact, CARICOM, the heads of government, quoted, and the other organ had notice.
yes, Your Honor, and we submit that they had noticed based on the fact that other member states notified the heads
Correct.
and quoted, and we say that that duty was largely, not largely, squarely on Gaitrine to issue that notice. They are the ones seeking to implement restrictions, and so they are thus required to notify the competent organ to trigger what I refer to as the operative parts of 43 and 47.
That, more or less, you've told us about you've submitted on your procedural arguments.
On notice. Well, just one more point
Yes,
on
and
the
then you
issue of-
can go to the substantive.
Yes, Your
Thank
Honor,
you.
I'm grateful. So then the second limb of the procedure is the fact that throughout Articles 43 and 47, we find that these restrictions ought to be temporary in nature and they are to be progressively relaxed. And specifically in 43, Your Honors, the requirement is that the restrictions be temporary, but in any event, not more than a period of 18 months. And we submit that on the facts, it is clear. The local content policy and PSA being entered into in 2020 and the Indigenous Peoples Agreement being entered into 2022, those have long gone beyond the 18-month threshold required by the RTC. And so on those two limbs, we submit that it has breached the procedural issues.
Mr. Davis, I know you're about to move on to the substantive requirements. I wanted to zone in on one in the interest of time. In the submissions of Antigua and Barbuda, there's an assertion that the restrictions they don't meet the requirement of both provisions, that they be non-discriminatory. Can you explain why you've come to that conclusion?
Your Honor, so we have come to that conclusion based on our submissions relating to the breach of Article 7, in that the restrictions in their holistic form are discriminatory.
So that leads me to a very specific question. Do you think the standard of non-discrimination under Articles 43 and Article 47 on the one hand is the same as that under Article 7?
That is our submission, Your Honor.
Okay.
And that once the test in Myrie has been satisfied and subject to our arguments on the breach of Article 7, then the restrictions applied as a whole are discriminatory in nature and thus do not
So
conform.
even though we're dealing with restrictions that are placed by necessity on other community nationals, you think the comparator in Articles 47 and 43 would be locals? So in other words, you think that for the purposes of judging non-discrimination, you'd be comparing in those provisions the situation of other community nationals with nationals
And
of the country?
that is our submission, and precisely the test for the breach of Article 7 and the test in Myrie requires that the discrimination be on the basis of nationality only. And we submit that the entire remit of what Gaitrine has done constitutes a breach of Article 7 in that it is discriminatory on the grounds of nationality, giving preferential treatment to their nationals as opposed to nationals of other member states. And so in that regard, we submit that it cannot pass that limb of and I thank Your Honor for taking me into the substantive points, which was the first one I wanted to deal with, which was the discrimination. And so the second substantive point, if I can deal with then briefly, is the whole notion throughout Articles 43 and 47 that these restrictions, you can find it in 43 2C and 47 5, shall not exceed those necessary to deal with or to resolve the difficulties. Your Honors, substantively, that takes us into the whole question of the measure of hardship in Guyana and whether or not the actions implemented were proportional. But critically, for us here, we submit that the RTC deals with or largely answers some of the questions that will come up when, in dealing with this article. If I can go back to an argument I made previously, so following the submissions relating to notice, that if the competent organs were notified, and if the court will permit me, then the operation that triggers assists Guytree in answering the question of its measure of hardships and whether or not the restrictions were necessary and appropriate to deal with it. And it says plainly that once the operation of quoted is triggered, and COFAP, it shall establish procedures for periodic consultations, the objective of making recommendations to the member state. They are designed to assist the member state to overcome the issues, specifically balance of payments, assess the balance of payment situations, and also to provide advice as to alternative corrective measures that could be available to the state. And so we submit that in answer to the question of what is necessary, which is another limb, a substantive limb under Articles 43 and 47, COFAP and quoted are empowered to assist the state in that regard, and they could not have, because of course we have made the submission that they were not notified. Your Honor, if I could then briefly, I don't know my time, but I wish to deal with the final limb of the substantive
Yes, you go
argument.
ahead, please, yes.
Very well, Your Honor, I'm guided. So the final limb, which also runs through Article 43 and 47 as a common thread, is that the restrictions are to minimize damage to the commercial or economic interests of other member states. You can find that at 43.2b and 47.6a. Your Honors, we submit that if we are able to juxtapose to a situation where Antigua and Barbuda, or Antigua and Barbuda, is considered a less developed country, then we submit that throughout the treaty, special provisions on regard is had for the situation of a less developed country. And I think it is beautifully summarized in the preamble, where the member states acknowledge further that some member states, particularly less developed countries, are entering the CSME at a disadvantage by reason of the size, structure, and vulnerability of their economies.
Mr. Davis, where on the facts have you seen anything suggesting that Antigua and Barbuda is a less developed country of CARICOM?
So we have juxtaposed that. There is nothing on the facts to suggest, but we have juxtaposed the situation in the facts to the real life situation, and the state of Antigua and Barbuda being actually a less developed country itself. But in any case, if Your Honor does not permit me to have that less developed characterization of Antigua and Barbuda, the onus is still on Guytree to ensure that their restrictions minimize the economic and commercial damage to the other member states. The fact that it is less developed only enhances that onus. But in any case, on a factual basis, we submit that these restrictions factually can affect the state of Antigua and Barbuda's commercial and economic interests. For instance, if its nationals are permitted to move and establish businesses, then Antigua can remove from the state of Antigua necessary government revenue, for instance, in the form of taxation when its nationals move and so on, and also remittances. We know how the Caribbean works. When people go to move, they will send back home. And so we're just saying that the state of Guytree has to be cognizant of the fact that these restrictions are to minimize the economic and commercial damage that it does to other member states. If I can wrap up then, Your Honors, briefly touching why we say that the state of Guytree has no protection under Article 30. And we raise it because Article 30 has a very wide ambit in excluding what it refers to as the activities in the exercise of governmental authority from the operation of the chapter. But very critically, there's an exception to that, in that activities done on a commercial basis do not fall within the scope of what it means to be an activity in the exercise of authority. And we submit, Your Honors, very briefly, that it is clear the very nature of these local content provisions, the LCP, the PSA, is commerce.
Mr. Davis, was Article 30 raised by Gaitrin
No,
in
it
its
was,
defense?
it was not raised.
Okay, but you still think it's necessary to proceed on this limb?
We might have raised it, but just to illustrate the point that it is not, there is no protection for this exercise of governmental authority under Article 30.
So you're asking leave of the court? to
Yes,
raise-
with your leave, your honors, if I can just raise that. Just to finish the point, this court, in the first of the Ellis trilogy of cases, dealt with the entire issue of the exercise of governmental authority. And in defining commercial, it went to the general agreement of trade services. It simply says that commerce or on a commercial basis are activities done to a financial or profitable end or for financial return. And we submit the definition of local content is the very definition is the monetary value of goods and services, and also the very nature of these sorts of agreements is commerce, and so Gaitrin does not benefit.
Davis, I
from
think you're close to running out of time, but I just wanted to go back to a little something very quickly.
Yes, Your Honor.
You say that the state of Gaitrin didn't raise Article 30 as in their arguments, correct?
Yes, Your Honor.
You know, I'm just curious why, as an advocate, you raise it. If you raise it, then you give them an opportunity to maybe rely on it.
Well, they have not raised it in their reply. We raised
I
it.
just wonder on your strategy why you would raise something that they have not raised that can only possibly benefit them. Even though you say it is of no avail, but you give them an opportunity to consider something because you've raised it. So, but I'm just making that as a comment. I'm just curious.
I am getting it. I think to answer your question, I think we raised it just to illustrate that this exercise of governmental authority is not protected in the way in which they have done it.
All right.
Yes, sir.
I think that's it.
And so with those are, there can be of no further assistance to the court.
Thank you very much, Mr. Davis. That is the case for Antigua and Barbuda.
May it please the court. I am Antonisha Henry, appearing as senior counsel on behalf of the Republic of Gaitrin. For 20 minutes, Your Honors, I will make 4 submissions. First, that the community agreement between the Kalino and Locano indigenous groups and Hexmobile is not attributable to the Republic of Gaitrin, and therefore any alleged breach of the revised Treaty of Chagaramas that may arise on this agreement is not attributable to the Republic. Secondly, that Gaitrin's local content policy and production sharing agreements do not breach Articles 32, the right of establishment, and Article 36, the right to provide services under the revised treaty. Thirdly, that Gaitrin has not imposed any new requirements for the movement of skilled nationals into the Republic of Gaitrin or within the Republic of Gaitrin, and therefore has not breached Article 46 of the revised treaty. And finally, Your Honors, that the claimants have not made out a breach of Articles 32, 36, nor 46, and there is therefore no breach of Article 7, discrimination on the basis of nationality only. I will now begin with my first submission, the community agreement. And first, I would like to say I am very pleased that the claimants have raised the argument of responsibility, that a balance is to be struck. Because this community agreement is not attributable to the Republic of Gaitrin. Gaitrin is not party to the agreement, And according to the articles on responsibility of states for internationally wrongful acts, under Article 8, attribution arises where the action is carried out by an agent of the state on official instructions of the state. The facts do not present where the Republic of Gaitrin has given official instructions, and there is nothing also to suggest that the Kalino and Locano indigenous group or Hexmobile acted as an agent of the state. We further submit the case of the Maya Leaders Alliance against the Attorney General of Belize that indicates that indigenous land rights are indeed protected. Therefore, any agreement brokered between Hexmobile and the indigenous groups would have been in consent of the indigenous people.
But presumably, Ms. Henry, you're not making that argument to suggest any connection between the actions of Hexmobile and the state.
No, Your Honor. Because our submission is also that the time difference between the community agreement and the production sharing agreement, as well as the local content policy, would suggest that Hexmobile for 2 years did not fulfill its obligations to the Republic of Gaitrin, and that is not the case. The facts do not present that, and we therefore do not have reason to believe that there is attribution of the community agreement rather to the Republic of Gaitrin.
Ms. Henry, I'm interested in an aspect of the case concerning indigenous rights. In your view, if there were a breach by virtue of the community agreement, would you think that it would be a proper argument to make that the indigenous rights trump the rights of nationals in the community under the treaty? Would that be an argument you would want to make? And if so, why?
Your Honor, we submit that the more important question is not whether the rights of community members are trumped by the agreement with indigenous peoples, but that the two should be considered separate. The rights of the community members arise from Gaitrin's obligation to the community, and we submit that Gaitrin has not breached any of its obligations to the community.
Yes, thank you very much. Thank you. You may proceed.
On our second submission, the local content policy is a policy. It is not an enforceable law. And as considered by the International Tribunal for the Settlement of Investment Disputes in the case of ConocoPhillips against the state of Venezuela, the tribunal considered whether a bill which is in force amounts to the breach of a treaty obligation. A bill rather which is not in force amounts to the breach of a treaty obligation. And it was held that a treaty's obligation can only be breached from a law which is in force. Since our policy is not in force, given that it has no penalties attached to it, then we submit that this court could take a similar posture to the tribunal in ConocoPhillips when considering the policy at bar.
Ms. Davis, isn't there jurisprudence of this very court that doesn't concord with what you're arguing?
We submit, Your Honor, that it is actually in reverse, that there is jurisprudence of this court in the case of Maurice Tomlinson against Trinidad and Tobago and the state of Belize, which, point of clarification, opposing counsel mentioned as Tomlinson against Dominica. But in that case, at paragraph 21, the court considered whether obligation is breached by mere existence of impunged provisions.
Ms. Davis, I'll be more pointed. Wouldn't the court in that case have clarified that acts of the state may be constituted by various branches of government?
Yes, Your Honor, that is indeed the case. However, the the act that we would consider today would also be substantiated under the treaty, under the revised treaty, and particularly under Article 30 that provides us with an exception for the state action, which indicates in Article 30, paragraph 3, subsection B, that statutory system of social security or public retirement plans shall be excluded from the operation of the chapter. So that,
Are relying on Article 30.
yes, Your Honor, since it was raised by opposing counsels, Guytrin actually submits towards our intention, the intention behind our policies, the intention behind this production sharing agreement with Hexmobile, as from the jurisprudence of this court as well, we found in the case of Ellis Richards against the state of Trinidad and Tobago that the court considers very heavily states' intentions in exercising their governmental authority.
What are the activities involving the exercise of governmental authority in this instance? So if you're relying on Article 30, please guide us what you consider, based on the facts of this case, are activities involving the exercise of governmental authority.
Well, precisely the local content policy and the production sharing agreements, which were created with the aim of ameliorating the serious economic crisis that Guytrin has been facing for decades, as the facts outline.
So you consider government regulation to be an activity?
Yes, Your Honor. Yes.
Okay, and you're maintaining this argument even though the purpose of Article 30 is to exclude from the scope of Chapter 3 certain activities from the exercise of rights by other community nationals? Are you suggesting that other community nationals would be purporting to conduct government regulation?
No, Your Honor, that is not my submission. Our submission is that under Article 30, paragraph 3, subsection B, that outlines the exercise of governmental authority, that the strategies, the actions that Guytrin has now implemented would fit squarely in subparagraph B as the statutory or social security regulations or public retirement plans. Just by way of the fact that when the Guytrinian nationals are employed in the petroleum sector, that this will in turn develop the economy, promote economic interests, and therefore return public retirement plans or contribute to same.
I believe we follow you, Ms. Henry. Ms. Henry, though, let us know if you could take us back, apart from Article 30, to those matters that you spoke to in Tomlinson. Tomlinson speaks about state practice. Are you saying that the PSA, the Production Sharing Agreement, is not an example of the state practice in Guytrin?
Your Honor, there is also another, well, first to answer your question, yes, it could be considered a matter of state practice. However, the construction of state practice we submit is two-pronged. So it does not only fall squarely within the argument that there is action of the state, but it also requires consistency. And from what we have on the facts, Guytrin has made this policy only with Hexmobile. And there is not another action that can be attributed to the state whereby there is an additional multinational corporation, or where, for instance, members of the community have tried to enter into the state and have been denied on this basis.
Ms. Henry, this requirement of consistency, isn't that more relevant to establishing customary international law?
I am guided, Your Honor, and I do agree with with your statement. However, we do submit as well that the element of state practice, as I explained, may be wrongfully phrased, but it does require also that there are, and as the case of Shanique Mary against the state of Barbados highlighted to us, that empirical data is necessary for the establishment of the state practice. And on our facts, that is not present. There is no other way to explain it, Your Honor.
But in Shanique Mary, wasn't that statement relevant to establishing a pattern of discriminatory conduct?
Indeed, Your Honor, it was. It is also a part in analyzing, explaining Article 32 of the revised treaty, which is the submission that is being addressed at this moment. Discrimination is also an element which arises, that by restricting the access or the right of establishment rather, and under Article 36, the right to provide services, that Guytrin would be discriminating against other community nationals. And that is the reason that we have raised the test that was present in Shanique Mary, that there is a high threshold for the establishment of this requirement of state practice.
Henry, I just wanted to ask you a little something about the production sharing agreement, because you have accepted that it could be a state practice. Is that unconditionally discriminatory? What do I mean by that? In the fact matrix, it says that they are required to give preference. But there's a condition, it seems, where their bids are competitive in several categories: skills, resources, ability, price, and meet technical and financial requirements. So is it a categorical discrimination that wherever there is a bid and there are local suppliers, you give preference? Or is it a case that you are only required to give preference where you have, as it were, all things being equal then? In other words, where all bids are equally ranked, then that is when you give preference. So if that is what the factual matrix suggests, my question is a situation like that discriminatory?
Your Honor, to respond to your question, if that situation would be discriminatory.
Well, first of all, is that what the factual matrix reveals? That it is not, does the factual matrix say that they are required to give preference?
Right.
Ipso facto, or is it that they are only required to give preference provided you have this
The other conditions.
that are equal to all other bidders?
Right.
Or are those all things being otherwise equal, then you give preference? Is that what it is saying on the fact?
The facts highlight that preference is only given to Guytrinian nationals where if we are considering the situation with Guytrinian suppliers, where their bids are competitive, where they are able to provide the necessary resources for HexMobile, and where they are also skilled. And for the situation of the Guytrinian nationals, that they are experienced and also very skilled. So if there was a blanket discrimination, those conditions would not have been attached.
So I suppose, does it really hinder, impair, or make it less attractive if it is that if the foreign bid is more competitive, or you have better skill or more resources, then this provision, this condition does not even arise? Agreed?
Agreed, Your Honor.
So how does that impact this assessment of a breach of these rights? Because first of all, there are certain rights we're talking about, the right of establishment. Does anything in this prevent them from establishing? Does anything prevent them from moving persons or moving capital?
And No, there is nothing in the local content policy nor the production sharing agreement which prevents the rights as established under Article 46 nor 30.
Argument is that it disincentivizes because of this preferential clause. But you have just said that the preferential clause is conditional on all things being equal. So my question is, when you have to balance it out, from your point of view, is that ipso facto a breach of the rights that are asserted?
And we submit, Your Honor, that no, it is not ipso facto a breach of the rights that have been asserted. And junior counsel will elaborate further on these points, that any breach that the court may find will be wholly justified under Articles 43 and 47. However, the reason for us also conducting an analysis of Article 30 is to establish that within the framework of Chapter 3, that this caveat is provided where guide-train under paragraph 3, subsection B, is permitted to make the actions, to take the actions that the state has taken. And also to highlight that the conditions are attached to the requirements in the LCP and the PSA. So there is no blanket discrimination. There is no discrimination on the basis of nationality only.
You have more to tell us, Miss Henry?
Just to emphasize, Your Honors, that in the jurisprudence, this court, in all the decisions that have been made thus far in the original jurisdiction, that the bench has given heavy consideration to the intention of the state, to the intention of the framers of the revised Treaty of Chaguaramas, and the teleology behind the revised treaty. That is, and even the president of the court this morning addressed to us that the treaty is ambiguous in certain respects. And that ambiguity leads from the fact that states are sovereign, regardless of the community that we build and the agreements within the revised treaty that we intend to follow. The state has certain rights in sovereignty, and those are also provided for within the treaty. In Cabral Douglas at paragraph 16, that very action was considered. Also the case of Maurice Tomlinson at paragraph 59 and Ellis Richards in paragraph 154. So we submit, Your Honors, that instead today of looking at the form that guide-train's strategies have taken in a bid to ameliorate the serious economic crisis that the country has been facing, that you look beyond form of the policies and into the substance of the agreements, which the only purpose is to help our country, to help this state that has been classified by the IMF as a highly indebted poor country. And if I may be of no further assistance to the court, these are my submissions, and I will now invite junior counsel to address the court that if an alleged breach is identified, that these are wholly justified under Articles 43 and 47 of the revised treaty. It was my pleasure to appear before Your Honors today, and I thank you.
Thank you very much, Ms. Henry. Lam, is it? Thank you. Go ahead, please.
Yes, Your Honor. May it please the court, my name is Simon Lam, and I appear as junior counsel for the Republic of Guytrain. It is Guytrain's submission that any purported breach of Articles 32, 36, 46, and 7 of the revised Treaty of Chaguaramas is wholly justified under Articles 43 and 47 of same treaty. First, Your Honor, junior counsel acknowledges the limitations imposed on the applying of restrictions under Article 47, that is, the requirement to notify COTED. We submit, Your Honor, we acknowledge that we are in the court's hands regarding this article, but we submit that we should be allowed to rely on this article notwithstanding, based on the fact that COTED has been made aware of our policies for the last 3 years, and furthermore has since formed a working group to address said policies for the last 3 years, but is yet to render any communication to the
So are
Republic
you
of
therefore
Guyana.
say that even if the state didn't take the formal step of notification, the undisputed facts of this case are that since 2022, there has been constructive or effective notification?
Yes, Your Honor.
All right.
Mr. Lam, what do you think is the purpose of notification?
The purpose of notification, Your Honor, is to allow COTED to guide a country such as Guytrin as to, firstly, whether these restrictions are a breach of the revised Treaty of Chaguaramas, and if they are not a breach, to guide Guytrin through the process of applying restrictions to alleviate its economic hardships. Your Honor, we submit that since COTED has not rendered any decision on the policies imposed by Guytrin, that Guytrin is not acting in breach of any relevant deciding authority of the revised treaty, and therefore should be allowed to apply the restrictions under Article 47. Next, we should be allowed to apply our restrictions.
As a question of law, what are you relying on? A presumption of regularity then? If, in other words, the fact that COTED knows, the fact that COTED has not taken any steps to censure or put any conditions in place, that you are therefore saying, as a question of law, this court should operate on a presumption of regularity, that the COTED, as you put it, has in a way represented that there has been no reason for Guytrin not to persist in the restrictions.
Yes, Your Honor. COTED has not presented any reason for Guytrin to change its policies or to move away from the restrictions that it has imposed. Article 47 provides that restrictions are permitted under the treaty where the exercise of rights by foreign nationals causes economic hardship in the host state. The restrictions are confined to one economic sector, and the restrictions do minimal damage to other member states. Your Honor, we submit that it is plainly obvious that the exercise of the right to freedom of movement of skilled workers by other CARICOM nationals will exacerbate economic hardship in the Republic of Guytrin. Guytrin suffers from high levels of unemployment, fluctuating prices, and other severe economic conditions. If the nationals of other states of the revised treaty of other CARICOM states were allowed to immigrate into Guytrin, we submit that they would outcompete Guytrinian locals and prevent them from accessing the necessary jobs in the petroleum sector to alleviate Guytrin's economic hardship.
Mr. Lam, you maintain this even if services aren't being provided through people moving to Guytrin? So you're talking about migration patterns, but how would the right to provide services, say cross-border, be impacted?
The right to provide services cross-border?
Through remote means.
Your Honor, if we submit, Your Honor, that the right to provide services by Guytrinians would be impacted as, say for example, there was a remote job in the petroleum industry at HexMobil. If that job is provided to a different CARICOM national who has more opportunity than a Guytrinian local, in that sense, the Guytrinian local has been outcompeted and replaced by a different CARICOM national, and our unemployment rate remains high. The Guytrin population does not benefit from the new petroleum industry and the remote work that it has created, Your Honor. Furthermore, the restrictions imposed by the Republic of Guytrin are only confined to one economic sector, the petroleum industry. We have not imposed any restrictions on any other economic sector. If a national of the state of Antigua and Barbuda per se wishes to work in the tourism industry, the mining industry, or the agricultural industry.
Mr. Lamb, is that really true? I mean, would the petroleum sector only be, let's talk about procurement. If operators in the petroleum sector need to procure, say, services, you're saying that these measures would not impact the procurement of services outside of the petroleum sector? Is it really that it's limited to the petroleum sector?
Yes, Your Honor. Our restrictions, the local content policy and production sharing agreement, are only relate to jobs in the petroleum industry and services for the petroleum industry. If a national of a different CARICOM state wants to come and work in a farm in Gaitrin, we have no problem with that, Your Honor.
But the production sharing agreement, let's use it as an example, provides that HexMobil is required to give preference to Gaitrinian suppliers.
Yes,
The
Your Honor.
petroleum sector might not need to have services outside of the narrow confines of the petroleum sector supplied to it.
Your Honor, we submit that those suppliers would be a part of the petroleum industry since that new service, that new business that they have is rooted in providing services to HexMobil, they would be a part of the petroleum industry, and the restrictions therefore remain confined to that industry, Your Honor. Finally, under Article 47, we submit that our policies and restrictions do minimal damage to other member states. On this point, Your Honor, we ask the court to note that we have not taken away any pre-existing rights for other CARICOM states, as this petroleum industry is a new industry. Before the introduction of our policies, Your Honor, there was no petroleum industry. And since the introduction of these restrictions, Your Honors, we have not taken away access to other industries for other CARICOM nations. And thereby we have done no new damage to these nations.
Yeah, Mr. Lam, your junior counsel for the claimant made a point about substantive requirements. It was the whole issue of, well, perhaps that was under his procedural ground, but that the treaty required that the measures be temporary and be relaxed where necessary. What do you say about that? And I think there's also a requirement for proportionality in 43. What do you say?
Under Article 43, Your Honor?
Yes.
Yes, Your Honor. We again acknowledge that we are in the hands of the court regarding the usage of this article, and we humbly ask the court to look to the purpose of Article 43, which is to address the economic difficulties and the severe economic hardships that Gaitrin is facing. We submit that Gaitrin is a disadvantaged country per Article 1B of the revised Treaty of Chaguaramas, as it is classified as a highly indebted poor country by the International Monetary Fund, the relevant authority for determining less developed and disadvantaged countries. Throughout the Treaty of Chaguaramas, Your Honors, the treaty makes special provisions for the acceleration of development for less developed countries. Returning this to Article 43, we ask this court to bring effect to the purpose of addressing the economic difficulties faced by Gaitrin. Should this court find that Gaitrin is not able to apply its restrictions legally under Article 43, this means that the policies imposed would have been for naught, and any potential gains, any alleviation of the hardships faced by the everyday citizens of Gaitrin would be completely lost, and the country would continue to wallow in economic hardship. In its past, Your Honor, this court has looked into the purpose of legislation brought before it to afford rights to people in its appellate jurisdiction and to bring effect to the purpose of lawmakers and not necessarily the plain text of the law. We humbly ask that this court do the same in this manner and bring effect to the purpose of the revised treaty to accelerate the development of Gaitrin and raise it out of its economic hardship under Article 43.
Mr. Lam, could you clarify something I see in the submissions of Gaitrin? In paragraph 10 of the defense, there's an assertion that the state is only restricting one area of freedom of movement. And there's an attempt to distinguish this case from the court's advisory opinion. What can you elaborate on what you mean by that?
By one area of freedom of movement, Your Honor,
Yes.
we are restricting the freedom of movement of skilled workers who are coming into the petroleum industry. If, Your Honor, if they seek to work in a different industry, the freedom of movement of those skilled workers is not restricted. The reference was made to the advisory opinion to the advisory opinion of this court, because in that matter, the court allowed St. Kitts and Nevis and Antigua and Barbuda to completely opt out of the freedom of movement for two categories of skilled workers, security guards, two categories of skilled workers, Your Honor. Whereas here, Gaitrin only seeks to restrict the freedom of movement for one category of skilled workers.
But Mr. Lam, wasn't that opt-out arising from a decision taken by a competent organ of the community?
Yes, Your Honor, it
And
was.
is this not a unilateral act? Is this not an action taken unilaterally by the state of Gaitrin?
Yes, Your Honor, this is a unilateral action by the state of Gaitrin. However, this action is less than the opt-out taken by St. Kitts and Nevis and Antigua and Barbuda. They completely opted out and prevented the freedom of movement of skilled workers, whereas Gaitrin, the Republic of Gaitrin, continues to allow the freedom of movement of skilled petroleum workers, particularly where they are more skilled and more competent than our own. We have restricted this right and not opted out of it completely, Your Honor. Furthermore, we submit that we are allowed to use Article 43 as our policies do not discriminate among states, they do not exceed what is necessary. Again, they minimize damage to other states, and our restrictions are used only for economic stability.
Mr. Lam, do you agree with the interpretation of non-discrimination that the claimant has assigned under Articles 43 and 47?
No, Your Honor. We disagree because the entire purpose of restrictions is to restrict other nationals from entering our economy and to benefit our citizens. There is no reason that we would restrict access of our own citizens to jobs that they need to help them. And instead, Your Honor, Your Honor, we submit that the non-discrimination of Article 43 is non-discrimination between other CARICOM states and third parties, meaning the non-discrimination is to say that we must not prefer the nationals of Barbados to the nationals of Trinidad and Tobago, or we must not prefer the nationals of the United Kingdom to the nationals of Jamaica.
Thank you.
Next, we submit that our restrictions are absolutely necessary to furthering Gaitrin's economic development. There is simply, unfortunately, Your Honor, there is no other way to ensure that Gaitrinians have access to jobs in the petroleum sector, and no other way to stabilize our economy without applying these restrictions. One purpose of the revised treaty
You
of
just have a little over a minute, Mr. Lam, so you can try to wrap up as you mentioned that point. Thank you.
Thank you, Your Honor. Gaitrin seeks to become a strong producer of petroleum for the entire Caribbean single market economy. And to do this, we first need to build a firm foundation in our own country. Before we can pour into the barrels of Antigua and Barbuda or any other CARICOM nation, we must first fill our own barrel so we can then share the prosperity of petroleum with the entirety of CARICOM. Finally, Your Honor, we ask this court to note that our actions are also taken in accordance with customary international law, such as Article 2, Paragraph 3 of the International Convention on Economic, Social, and Cultural Rights, which allows less developed countries to restrict the right of work for non-nationals. May it please the court, Your Honor, this concludes my submissions. We asked for relief that the court find that Gaitrin is not in breach of Articles 32, 36, 46, or 7 of the revised Treaty of Chaguaramas, or alternatively, that if we are in breach, these breaches are wholly justified by Articles 43 and 47. Unless I am of no further assistance to the court, the respondents rest.
Thank you very much, Mr. Lam. Antigua and Barbuda, you have a reply for us? Mr. Davis?
Yes, Your Honors. May it please the court, I wish to address Your Honors on just a few matters in reply. And I wish to begin, Your Honors, with the reference to the case of Maurice Tomlinson. And in paragraph 22, it can be gleaned there that the government can be liable for breaches of their international obligations based on actions of all three branches of the government. And so this policy flowing from the executive no doubt constitutes an action of the government. We submit further that based on the provisions in both the LCP and the PSA, that the PSA is the evidence of the state practice of the government of Gaitrin in implementing its local content policy, because the provisions are largely mirrored. And so this PSA with HEX is the evidence of the state practice. And then, as it relates to the Indigenous Peoples Agreement, there was reference drawn to the draft articles of responsibility for states for internationally wrongful acts. And in the commentary, 38 and 39 of the commentary says specifically that conduct is attributable to the state and that of its organs acting under direction, instigation, or control of those organs. Our submission plainly is that the IPA flowing from the PSA is under the instigation, at the very least, of the government. The government is party to the agreement with HEX. It is bound by the agreement. And if I can perhaps paint a map in the minds of the court, that within the operations of the PSA is a portion of indigenous lands. And so flowing from the PSA, naturally, in order to carry out its operations under the PSA, it has to encounter the lands that indigenous peoples occupy. And so the government being a party and backing this PSA has also, at the very least, instigated the operations which led to the agreement between HexMobile and the indigenous persons. And on that basis, we said the government can be liable for that agreement as well, insofar as we submit it breaches 32, 36, and 7. Your Honors, then I wish to move on to the whole notion that there is not an absolute restriction. And I think my learned friend agreed with Justice Jamada that at most, if I can give them that, it disincentivizes. And we say precisely that this fits squarely within the definition of what we submit a restriction is, because disincentivize is at the very least to render less attractive. And we say that is an important tenet of the definition of restriction, so that if it disincentivizes, it can have the potential to render less attractive, and we submit that that is not permitted under our definition of a restriction. And so there's no need for an absolute restriction on the rights. It is that at the very least, it must hinder and render less attractive the exercise of rights by nationals of other member states.
Mr. Davis,
Yes, Your Honor.
let's suppose you reach there, and let's suppose we pass over the formal requirements of notice and so what you call the procedural, you remember you said the procedural
Yes, sir.
aspects. In balancing what is justifiable or permissible in these circumstances, how would you respond to how this court should approach the question of that balance? Do you understand what I'm asking you? So you're arguing first for an absolute breach of the rights. In other words, the rights are breached.
Yes.
But the provisions allow for limitations,
Yes.
right? Restrictions on the rights.
Yes, Your Honor.
You have argued that they were procedural non-compliance. Right. Let's suppose that's not troubling this court. What we're left with then is, based on what you've just said, is making something less attractive. It's not a total prohibition. It's not in that area even if it runs afoul on this lower threshold of less attractive.
Yes, sir.
But then justification, because the factual matrix tells us about the economy, etc., etc., etc. How should this court, without getting for the moment caught in the formality, non-compliance with notifications, how should this court work out that balance in terms of the state?
So outside of the arguments of the procedure,
Yeah.
I think it is necessary when looking at restrictions implemented by a state to assess first the necessity and the proportionality, dealing with, in order to deal with the hardships that they claim. If I can bring it to the case at bar, where Article 43, for instance, contemplates an issue where there is an issue with the balance of payments, and it only contemplates two situations. It's the issue with balance of payments and external financial difficulties. Then it's
Both of which the factual matrix suggests may exist.
right, and so we have to get to the point where whether or not the restrictions implemented
Are
are necessary
proportionate.
and appropriate to deal with that situation. I would even submit on a
No, so
factual,
let's get to the facts. So,
yeah, so
okay.
on a factual basis, initiatives such as the training of Gaitrinians or investments in local research and development and so on that are provided for, we submit that we don't see how that is either necessary or proportionate, for instance, to deal with paying off an external debt to the IMF. And so that's one factual argument that we would make. But the bottom line is that whatever the restrictions are, if the court agrees that they are in some level of difficulty, then they have to show that these restrictions are necessary.
And so if the restriction is one that says everybody can bid, but only in a situation where bids are equal, prefer local, would you say that is an attempt at being proportionate? As opposed to saying, you can only consider local. You
Yes,
see
yes,
the-
Your Honor.
I'm just trying to understand from you, is that an attempt to be proportionate? And if it is, why would you say, because your case is that still runs afoul?
Yes, Your Honor.
Why would you say that runs afoul of the?
So,
Of the
in answer to your
RCA.
question, Your Honor, I think the factual matrix that you have painted in that question on our argument raises the issue of discrimination, which, as a tenant of 43 and 45, plainly, substantively, the restrictions are not allowed to do. And so, in a case where persons are equally qualified, but one still gets the edge by virtue of them being a Gaitrinian or by virtue of their nationality, we submit that amounts to a breach of Article 7, and we have submitted case law to the effect. It's
No,
from the EU.
I'm just, yes,
Yes.
okay. I don't want to take you further. You have limited time. I just
Your Honor.
wanted to see how you'd respond. Thank you very much.
Thank
so-
you, Mr. Davis. I think your time has run out.
Very, very well, Your Honor. So,
But I claim some responsibility for that. It's not your fault.
Is
Very
there
well,
anything that is very burning that you have not said before?
Your
Because
Honor,
the reply is for new information,
I-
new submissions.
I am most grateful to the court, Your Honor, only to say that the state of Antigua and Barbuda, we pray the relief sought that a declaration that Gaitrain has breached the articles 32, 36, 46, and 7, and that they are to amend to conform in that regard. And with those few submissions, I think that is the case for the state. Only to say that we are equally, as my learned friends, humbled and grateful to appear before Your Honors this morning.
Thank
Those
you
are my
very
submissions, Your
much.
Honors.
Thank you. Thank you to all. Right, yes. Thank you. Go and have a well-deserved lunch. Relax, come back in and enjoy the other group and continue to learn. Thank you so much. Madam Registrar, we will rise.